Hey, good morning, Judge.
Good morning. I'm right now we're live on YouTube, gentlemen, just so you know. I think I have to statutorily do that. Good morning, Mr. Gilchrist.
Good morning, sir.
I see we're waiting on the state now, I think, right? I think we should be waiting on the state. Talk to our coordinator, Leela. She's not available this morning. She has a doctor's appointment, but after this is over with, she will give us dates if we need dates. Okay?
Okay.
And Mr. Gilchrist, I don't have your pleadings in front of me. I asked Leela for them. She told me that one of the pleadings was so large it would not take on the scan thing. So I'm going to ask you to please summarize your pleadings for me when we
Okay.
get to that, when the DA appears.
Okay. So if I understand correctly, you haven't had a chance to read it. Is that correct?
I have not. If this is the pleadings to disqualify the current DA or
Yeah, the motion for sanctions against Miss Busby.
I have not seen that pleading.
Okay.
If you want to try right now to send it to me via email, you can, if you know how to scan and do all that stuff. But
that'll be a trick. Yeah, that'll be a trick. I can send you the actual pleading. It's the exhibits. It would be hard to send all at once.
Yeah, evidently, well, yeah, like I said, Leila had a problem sending it. So
yeah,
I thought it would be best if it could either, I'll ask you to one by one tell me what you have. And,
okay. All right.
We'll do it that way.
Yes, sir.
And then if you need to make a record of it later, you can send it to, well, you've already sent it to Leila, I think. So you
yes.
already has it. So
yes, I filed it back in, I think, January or the first part of February.
Okay.
January 29th, I filed it.
Okay.
So how'd your knee replacement turn out?
Well, my wife started forcing me to bicycle with her, and we were bicycling now for a long time before the winter hit. And anyway, the end result was my knee got stronger, and I can walk without a cane if there are no stairs that don't have rails on them. I can use stairs as a rail, but so I'm a coward. I'm trying to put off that as possible if I don't need to do it.
Yeah.
At age 70, I don't feel like I heal like I used to.
Yeah, well, I had 2 knee replacements. I had one last February a year ago, and it turned out well. Both of them have. So
good. I hear that. Well, I've had 2 hips, but I've always heard knee replacements are much more problematic and also harder rehabs. So
that's true. One thing my homemade lady did, she brought me one of those little pedal bikes where you can sit on the couch and pedal it like a bicycle, and that made all the difference in the world.
Yeah, movement, just moving the joint, right?
Yeah. You could be sitting there watching a movie and pedaling away.
Well, San Antonio has a bunch of bicycle trails that are really beautiful trails to ride on, and I think we've ridden on every one of them.
Well, that's good, especially being springtime.
Yep. Okay, I'm hoping the DA shows up. And I'm wondering, am I moving this to the day after, if that screwed him up?
Is hearing to move it to tomorrow or something? Is that what you're talking about?
No, it was supposed to be yesterday. We were supposed to do this yesterday, and I moved it from the 6th to 7th because I had another setting somewhere. Let me call you Uvalde up right now.
Okay.
She CC'd on this.
Would you happen to have
So
the DA's phone number?
I don't actually. Normally I would just call Layla, but yeah, she's at a doctor's appointment.
He has a doctor's appointment right now, so I don't. Let me see. Oh, come on, Paul. Maybe I can get the office number. Here's the work number. Okay, there we go. Hello?
Yeah,
This is Judge Canales from San Antonio.
it's Layla.
Hey, Layla, I'm sorry. I thought I was dialing the work number.
Oh, okay.
Okay. Can you give me the do you have the DA's number, Layla?
Yeah, it's 830-278-2916.
2915 or 16?
16.
16. Okay, I'm going to call them because they have not shown up for the Zoom meeting.
Oh, okay.
Okay, thank you. Appreciate it. All right, bye-bye. Okay, so. Zero. Is this the district attorney's office?
Yes, sir.
This is a visiting Judge Paul Canales. I'm supposed to be having a Zoom hearing with a Mr. Thomas Gilchrist and someone from the DA's office, and nobody is here from the DA's office. Yes.
Hello?
Hello?
Yes, I'm sorry. Your name was?
I'm visiting Judge Paul Canales from San Antonio. I'm supposed to be having a Zoom hearing on the Gilchrist matter. And I have Mr. Gilchrist, I have the court reporter, but I don't have anyone from the DA's office.
Let me go ahead.
At least we have good music to listen to.
Yeah, we got good classical stuff, huh?
Yeah.
Moonlight Sonata, Beethoven, right?
Yeah, I think so.
Okay, someone's just come in. This Busby's come in.
Okay.
Hello, Ms. Busby. I have your office on hold. I'm going to hang up on him if that's okay with you. No.
Judge, are you there?
I'm here. I had your office on hold. They have beautiful classical music for the whole music, by the way.
All right, I was
And
gonna
I just
call.
hung up on. Okay. This hearing is set, I think, from on Mr. Gilchrist's motion for sanctions and to remove you, I believe. And it's Mr. Gilchrist's motion. I don't have a, I'm sorry, I don't have a style in front of me. Do you have a cause number on your motion, Mr. Gilchrist?
Yes, it's 2017-04-13013-CR.
Okay. And what I'm going to do, since it's his motion, Ms. Busby, I'm going to call the case. I'm going to ask him to present his motion to me. Then I'll go to your response. Is that all right with you?
That's fine, Judge.
Okay. So, Mr. Gilchrist, this is in cause number 2017-04-13013-CR. South State of Texas versus Thomas Gilchrist. This case has been set on motions from Mr. Gilchrist that he has filed with the court. Unfortunately, I don't have copies of those motions in front of me. I do know that one of the motions is for sanctions and for either the district attorney to be removed or to be recused. I'm not sure what the actual wording is of your motions. Is there anything else? That's the general gist of what I think I have in front of me. Is there anything else I have before me in terms of your motions, Mr. Gilchrist?
Well, it was two motions. One was a motion to expedite to have this hearing on the motion for sanctions against District Attorney Christina Busby.
Okay.
And basically the gist of the motion, the punishment for the sanctions is to dismiss this case once and for all with prejudice, so it can never be tried again. And I stated in very detail in my motion the examples of why. And basically, I look at it this way: enough is enough. And so what the motion starts out with is, I'll give you kind of chronological history.
Please.
We had a hearing back on, I think it was December 8th of this past December. And at that point, I had motions before the court to do the depositions of 4 of the district attorneys. 12 hours before the court hearing on December 8th at 9 o'clock in the morning, Ms. Busby filed a motion basically objecting to all this, state's motion. And she made a lot of comments in this motion that were just totally untrue. And the gist of this is that she has misled the court. And I can go into detail, but I'm going to give you an overall outline right now. And so that was when we started talking about doing mediation. I was kind of receptive to the idea. And so that night on December 8th, she sent me a motion for, to sign off on a court's order on your instructions from that earlier that day, to form. And so during the court hearing on December 8th, when we were discussing the mediation, one of the things that came up was whether or not we could legally do this in a criminal court versus a civil court. That was one issue that you had asked her and I to research. The next issue was the fact that I was to pick 3 possible mediators and she was to pick 3. And between those 6, we would get together and try and decide, narrow it down to 1. And you said that if we couldn't come to that agreement, then you would come in and make a decision for us. Well, in her motion that she filed that night and sent to me, she has language in there that she was going to give me a list of 3 licensed attorneys to act as mediators. Well, in the state of Texas, you have to have a licensed mediator to do a mediation. You don't even have to be an attorney to do a mediator. And so, and then on top of all that, she never afforded me the opportunity in that court order that she drew together for the 3 of us to sign, giving me the opportunity to pick 3 people. And so that's one of the big problems. So I didn't sign off on it. In the meantime, I talked to Micah. He and I worked together a lot on court transcripts. And the next day I requested a copy of the court transcript. Well, normally he and I, I get something within 10 days. He gives me an estimate. I send him a check. Once I send him a check, he sends me the deal. Well, I didn't get my court transcripts till January 16th on a Saturday. And I have nothing, absolutely nothing against Micah. I don't think this is his problem. But the thing to point out in this is in Miss Busby's motion, uh, or the court order, there was basically a January 15th date that if I signed off on this thing, she would get me the list, no later than January 15th. So I took that as an implied deadline date. Well, that day came and won, and then ironically, the next morning I got my court transcript on Saturday morning. So I don't know this for a fact. My strong feelings is I think maybe Miss Busby had delayed my court transcript because that was the evidence I needed to point out where she had misled the court. And so, so basically, that's the gist of the situation. So the crutch of the argument is that she's been dishonest from day one on this thing. When she filed her motion to object to the deposition, she filed it 12 hours before the court hearing. And technically, under the Texas rules of procedure, she was supposed to file an objection with 3 days after I filed the notice of depositions. Well, she didn't do that. Weeks went by. And so to me, that's a default. Also, I basically, in my case law, I cited cases where a lawyer shall not knowingly make false statements of fact of law or to a tribunal, violate or attempt to violate the rules of professional conduct, engage in conduct involving dishonesty, fraud, deceit, misrepresentation, and engage in conduct that is prejudicial to the administration of justice. And so I went in and also brought in the Texas Disciplinary Rules of Professional Conduct, Rule 804 misconduct. And basically, a lawyer shall not violate these rules, knowingly assist or induce another to do so, or do so through the acts of another in the violation. In other words, I believe she engaged in conduct involving dishonesty, fraud, and deceit, and misrepresentation to the court. The reason why I feel that way is her statements that she had made in her state's motion saying that the DAs that I was trying to depose didn't have any factual information regarding my case, which is a lie. Because Julia, you and I were at the jury trial, and Julia Soyas, she was the lead prosecutor, and Jeffrey Dowles was the assistant. And we had that jury trial. And after that jury trial, after we dismissed the jury and it was a hung jury, Julia announced that she was going to retry this case. And if you remember correctly, you were pretty upset about that, that it didn't need to be retried and you didn't really want to be the judge. And as time went by, well, we continued forward and we're at to where we're at today. And so then she tried to say that me and Habe, Mr. Habe, he didn't have any information. Well, he was the main DA and he and I were corresponding in emails trying to work on a settlement, work out something last summer, pretrial disposition. And so he was knowledgeable of the case. Then she made facts in there that I didn't know anything about the case. Well, I've been pro se on this thing this case has been going on for almost 4 years. And half the time I've been pro se. And so anyhow, so it goes on, it says engaged in conduct constituting obstruction of justice, knowingly assist a judge or judicial officer in conduct that is violation of actable rules or judicial conduct of the law. So basically, your ruling that day on December 8th, you stated very specifically what needed to be done. And if you go back and look at her court order that she drew up on your behalf, she didn't put all the stuff in there that you instructed us to do. And that's coming back to where I had an opportunity to pick 3 mediators. And at the same time, she was picking 3 licensed attorneys, not mediators, and licensed attorneys to act as mediators. She totally went against your court ruling that day. All right, so in the next section, I state the statement of facts. Let's see. Oh, and another thing on Jeffrey Dowles. When I filed the notices of depositions, I drew them up on all 4 people: Julie Soyas, Jeffrey Dowles, Habe, and Kindred. And I filed them all at the same time at the courthouse. I go in, I get multiple copies done, and I mail original copies to every party. And when I left the courthouse, I went back to Concan and I went to the U.S. Post Office and I mailed it priority mail with tracing numbers. And in her motion, state's motion that she had before the court on December 8th, she claimed that I never, ever, ever had sent anything to Jeffrey Dials. So in my document that I filed with the court for these sanctions is copies of the tracing numbers. And I also went back to the Concan post office, and she printed out from her end, from the U.S. Post Office computer, printout showing exactly where they went, the day they went, and when they arrived. And so she flat out lied in the state's motion that Jeffrey Dials never got his copy. And Jeffrey Dials, if you remember, is the guy that I've been raising the argument about, that he falsified that document on behalf of Kindred, where it listed the Brady Act and the deal against the police officer. Well, that was the document that never got filed with the district clerk's office, but yet my attorney Minos had gotten a copy of it. And I've been raising that argument for the past year or so that there's something wrong with this. This isn't right. Because what happened was, when he typed it up, the certificate of service showed September 30th. And after he signed it, he realized it was after the jury trial, and he went back with the ink pen and changed the date to September 1 as if it was filed with the court and sent to my attorney prior to the jury trial. Well, the jury trial was on September 10th. And that was 4 days. I think it ran to the 14th in 2017. And that's been my argument all along, is after the fact, he created the document and tried to backdate it. And on top of it, didn't file it with the district's office, because had he filed it with the district office, they would have time-stamped it. And so the way I ended up with it is, when my attorney got sick and subsequently after that died, well, I had to obtain the copy of my files from his office. I called him up and he gave me the whole case file, and that's how I came across the document. And then I went and talked to him afterwards, and he confirmed that he knew about the document. All right.
When you say you talked to him and he confirmed, who's the him, please?
Mr. Minos, my attorney. When I left the district clerk's office that day, I went straight to his office. It was about 4:30.
I thought you were talking about Mr. Dials. I'm sorry. Go ahead.
Yeah, I'm sorry. All right. So moving on, I basically cited case law. Let's see. Let me look at this again. Okay, I covered that part. Let's see. Motion, knowledge of fact. Let's see. All right. In DA Busby state's motion, the sentence, quote, "The proposed opponents have no personal knowledge or fact alleged or previously tried in this case," end quote. That's a lie. Number 3, DA Busby states in her sentence, "The proposed opponents are not a witness in the current case and do not have information to the allegations as contained in the indictment, nor do they have information to the facts of the instant matter," end quote. That's a lie. Number 4, DA Julius Soyas was the lead prosecutor and the defendants in the jury trial September 20th. I've covered that. DA Jeffrey Dials was assistants. I've covered that. Daniel Kinyard was the district attorney in the Uvalde County 38 District Court at the time of the jury trial in September. It was 2018, not 17. I'm sorry. And then at the same time, Mark Habe, I was discussing with him, as I've already stated, we were working on a compromise. So all these 4 people have total knowledge of my case, but she flat out said in her state motion, that they didn't have any knowledge. All right, section 3, DA Busby states in a sentence, quote, "The defendant is aware of the fact," quote, "Busby is trying to convince the court that the defendant is aware of the fact that these people had no knowledge." That's not right. And then defendant Gilchrist is totally aware of the fact that DA Busby purposely misstated the facts, lied and perjured herself to try and convince you, the court, to the story of the facts to be true in order to gain sanctions against me. Because that day at the jury trial, or at the trial on December 8th, last December, she was pushing for sanctions. That's what she was asking for in her motion. Well, you didn't have a copy of the motion, and you kept on stating there's no other motions before the court, but yet she kept on trying to push you to get sanctions against me. In the situation, you made the comment to something to the effect that we'll address that at a later day. So going on. All right. One of the things that was mentioned, let's see if you can. Yeah, this is where you quote from I got this from the court transcript. One of the things that was mentioned was instructed by Judge Canales was, quote, "Miss Busby, if you could come up with some names, and Mr. Gilchrist, if you could come up with some names, maybe you could reach an agreement on mediation. I think it's important, though, that the parties agree on mediation, end quote. And I have an exhibit of that attached. In Exhibit F, the document agreed order for mediation, which was drawn up by Ms. Busby. This document is for Judge Canales, Defendant Gilchrist, and DA Busby to sign off on and agree to, quote, approved as to form, end quote. DA Busby emailed this document the same night of the court hearing. And so I couldn't sign off on the agreement. I was interested in doing the mediation if I wasn't going to end up waiving my rights, that if I succeed in winning on this criminal case, I'm going to go back and I'm going to go sue the defendants. And so I get the impression that this thing's being drawn out for almost 4 years because Roger Rosa used to run the grand jury. He used to run it for several years before he got sick. And he's a millionaire. Okay, he's got money. And then the guy that owns Neil's Lodges, the other person, Cody Davenport, which is the victim that filed the charges basically against me, you know, the deputy sheriff was on his payroll at the time all this happened, and Kevin Carr, and he did the investigation on this. And it came out in the jury trial. He was a sole investigator, and he admitted he was on the payroll, you know, with Davenport. And so now Kevin Carr, the reason why he got fired by the Houston Police Department, this all came out during the jury trials because he botched about 4 or 5 murder cases. He withheld evidence. He was bad in the paperwork. I don't remember the exact details. Well, ironically, he did the same thing with Uvalde County Sheriff's Department. He came up here and went to work for the Sheriff's Department after he got laid off from Houston Police Department. Well, he just got fired December 31st. He had a 2 weeks notice. They were letting him go when the new sheriff came in. But I found out through research that he was let go for the exact same reason. He botched all the paperwork, and that's why they got rid of him. And so that's the state's lead witness. That was their expert witness at the jury trial. Well, I don't know where he's at now. He's left. And so even if we proceed forward with the jury trial, I don't know if the state has a witness now. And then at the same time, with everything that's gone on for the last 4 years almost, you know, enough is enough. You know, all I did, and I've stated this before in court, I have a bill of sale. I own that cable system that went through Neil's. Roger Rosa illegally sold my system to Davenport. I went to 2 attorneys, Menus and Randy Crispin, and they both advised me I had the legal right to take my equipment. The only thing I took was 5 amplifiers to deactivate the system so they couldn't use it. It was my equipment. And had I known for one moment that I was committing a crime, I would have never done that. I would have let it go. Well, in the meantime, my 2 attorneys have died. Menus passed away, and Randy Crispin passed away after heart attack surgery here about a month ago. And so, you know, we're talking about 5 amplifiers worth $500. And so the crutch of my argument in this is enough is enough. The DA, she's fresh onto this case, effective for, you know, December, maybe in the fall. And the point is she's been lying right out the gate. You know, she's misled you with facts. You know, she didn't follow your court instructions. When she drew up the court order, she didn't follow your instructions. And as a result of it, here we go again on another delay. Because I wasn't about to sign off on the court order as to form because it was not right. And I feel she tried to trick me into signing it in the fact that she was going to give me a list of 3 licensed attorneys to act as mediators. And so that's pretty much the sum of the argument. What I'm asking for is let's dismiss this case once and for all. I'd like to have it done with prejudice so they can't ever come back. A lot of money's being wasted on trials, your time, the court time, you know, mediator. And it's like they don't play fair. I've tried to proceed with this thing, be cool, calm about all this. I follow the rules. I research the law. You know, and I will always do it by the book. And it's reached the point now where we're at an impasse. So I'd like you to consider what I've just stated.
Okay. That's your first motion, right? Is there a second motion?
The other motion was the motion to expedite to try and get this heard back in February.
Okay, and I guess that's a little late for that right now.
Yes. Yeah. When I didn't get anything from Leela, I reached out to her. I guess it's been about a month ago to, you know, remind her there was the motion to expedite, and that's all it is.
Okay, and I apologize, but I have a busy schedule outside of Uvalde in
No,
Bear
no,
County.
I understand.
I couldn't fit into my schedule. Okay, Ms. Busby, could you give me a response? And do you have any counter motions that were filed?
No,
Oh.
Judge. So on the motion to expedite, I think that's moot. On the motion for sanctions, regarding his oral argument. Okay, so following the hearing, I did send him a proposed order for mediation following our discussion at that hearing. He did not sign it, nor did he send me any suggested revisions or things he wanted to change. He didn't send me anything. So because he didn't sign it, it was never forwarded to the court, because it was my understanding from you when I suggested mediation that you wanted to make sure that we were all in agreement about that, because it's so different in a criminal case. So because the defendant did not sign that, Judge, I did not even bother to forward it to you, because I didn't think we had an agreement. And yes, I did propose, I was going to send him a list of 3 licensed attorneys, because I need, whoever's going to mediate this case has got to be a criminal attorney, or have some criminal background to understand the legalities and nuances of this case, and also how it would affect him in a disposition and final resolution. So I wanted to make sure there were licensed attorneys. I don't want anybody that doesn't have a legal background or has a license from the state of Texas. So again, I did not even bother to send that to you. With regard to his allegation that I somehow prohibited him from getting a transcript from the court reporter, I didn't have any idea he'd even asked for it. Micah and I never even spoke about it. So again, but that is an example of how he brings these kind of things up with, just these crazy suggestions. I would never do that, and I didn't do that. Now he keeps going back to and you've already ruled on the discovery motions. And I think he needs to understand that just because you tried a case as an attorney does not mean that you have information or firsthand knowledge about the facts surrounding the charge with which he's indicted on. Because Julie Solis, Jeff Dials, Mark Habe, and Danny Kindred were somehow former prosecutors on the case does not mean that they are fact witnesses on the facts or allegations of the indictment. And so that's right. I'm going to continue to file motions to quash anytime he's going to try to subpoena a prior prosecutor as a fact witness. They don't have any information of the charge with which he's indicted on. They may have information about the trial and any plea agreements made, but they don't have any information on the trial. There's not a motion to dismiss pending before the court. So I don't think that is proper before the court today. I would like to consider mediation again, but it's very difficult with Mr. Gilchrist. He does, like I said, I sent him a proposed order. He does not communicate with me. Instead, what he does is files motions for sanctions. Judge, he also filed a grievance. So, and it's what he's done before. And, those things prohibit the case from moving along. So that's my response, Your Honor.
Okay.
Rebuttal, Your Honor.
Yes, sir.
Okay. On the licensed trial attorney, I understand what she's saying, and I've scoped out a couple of licensed trials attorneys that are also licensed mediators. I'm not going to give the names at this point. And I understand the concern that, we just don't get Joe Blow down the street and he's got a licensed mediator license and he doesn't have a law background. I understand that concept. And secondly, as far as Julia and Jeffrey Dials and everybody, they got the my case in their possession. So when Julia was prosecuting the case, or Jeffrey Dials was prosecuting the case, and even with Mark Habe being, the prime district attorney, the whole case file regarding the indictment and everything is in their file in their office that all the DAs have access to. And then secondly, the motion for the grievance, the only reason why I filed that was when everything started getting delayed, that I wasn't getting my hearing. Yeah, I went ahead and filed the motion for grievance against her. And what I did in my exhibits is simply point out the facts. I'm not a type person that tries to make stuff up. I try to deal with the facts. If the facts aren't there, I'm not going to state it or quote it. But I'm going to mail you a copy of this document. And when you look at it, you'll see that I left the feelings and emotions aside and set them at the door, and I dealt specifically with the facts. And let's see what else. The reason why I was trying to do the depositions against the 4 DAs, it comes back to it wasn't a fishing expedition per se. I was going to keep it limited scope. What I was trying to do is find out who knew what, when did they know it, and what did they do about it on this document that never got filed, that Jeffrey Dials drew up and never got filed with the district clerk. I was going to subpoena email records strictly showing, did he email it to my attorney? And at the same time, I was going to depose the son of Mr. Menus to find out email records is how did he get it? I was trying to trace the history of who knew what, when did they know it, and what did they do about it. You know, I'm not a type person that I'm just going to go on a scavenger hunt. You know, I'm doing this by the law book, and you got to understand my mentality. I set feelings and emotions at the door, and every time I walked into your courtroom, I've always tried to deal with the facts and present the evidence. And I was real careful putting this sanctions together. And this is a motion for sanctions. And part of that motion is to dismiss this case once and for all with prejudice. So yes, there is a motion before the court to dismiss this case, contrary to what she just said. And so basically, I'm just saying right from the get-go, it got difficult with her. You know, the old saying, she's not playing fair, but hey, nothing's fair in life. And I understand that. But the point is I'm not trying to, you know, when I do pick a mediator, it's going to be a licensed criminal or trial lawyer that has a license to do mediation. And one thing that I'm concerned about is if I agree to a mediation as we move forward, I want to make darn sure that I do not waive my right, that if I win this thing, it doesn't prevent me by signing that mediation. And this is why I've been hesitant about filing, pretrial dispositions, is I do not want to lose my right to go after these people when it's all said and done, if I win, to sue them. That's what I'm protecting.
Your Honor, may I respond to that? You know, I'm not your attorney, Mr. Gilchrist, but any civil attorney is going to tell you that your statute of limitations to sue these people has already passed.
I've already talked to attorneys and they're standing by ready to do it if I win this.
Okay. Well, I would like
it's not past the statute. Normally it would be past the statute of limitations. I think it's 2 years, but this restarts the clock on all that, because that's one thing I wanted to make sure.
Let's not go there. That's not before me. I really.
Okay.
All right, let's talk about first things first. I had ordered this case. I'd ordered you guys to come up with names for mediation when it was suggested. I don't believe I suggested it. Somebody suggested that this case go to mediation, and I don't remember who it was.
It was supposed to be.
Mediation from the civil side, Mr. Gilchrist. I'll just tell you, from the civil side, mainly, it's mediation is done a lot in cases involving car wrecks and involving marriages. And it usually, any mediator is usually going to be a licensed attorney. That's because of the nature of the beast. It's usually a retired judge. Let me finish. It's usually a retired judge or a licensed attorney who has gotten themselves licensed as a mediator. And generally, you tend to go with those people because they have experience in the legal field. All right. That's in the civil side. I'm just telling you. On the criminal side, it is very rare. I've heard of cases going to mediation on the criminal side. It is very rare when cases go to mediation, but I've heard that they do. But in order, again, I'm thinking from a judge's point of view, if it's going to be a mediator that I would pick, it would probably have been a licensed criminal lawyer, because I feel they know the law pretty well. But mediation does not only involve, that involves people skills. That's why you go get licensed to do it. It involves trying to get people to move from their positions. And I'm a licensed mediator, and I do it. I hate mediation. I'd rather be a judge. It's much easier to say you win, you lose, than to try and get two people who come to the middle on something. And on a criminal case, it's especially difficult. So I was kind of surprised when the mediation thing came up. And when I asked for a list of 3 names, you could have given me 3 names of whatever people you wanted, and she could have given me 3 names of whatever people she wanted. And it would not have mattered to me. I probably would have gone with some kind of licensed attorney, because I'd have more faith in an attorney knowing the process. But that's neither here nor there. It never came before me. We don't have an agreement, but I do want you to know this: even if you'd gone to mediation and you'd had a mediation agreement and you didn't make an agreement, none of that would have been used against you because it is all privileged and cannot be used against you in court. That's a general rule about mediations, all right? Unless you sign a mediation agreement where you agree to do something, then that's a different story. But it never got to that, and that's
No.
all right.
No, I understand, Your Honor. I've done mediation before. I'm on the civil side,
Uh-huh.
and so I'm well familiar with the process and what all's involved. And I also understood. I was like you. I didn't know we could do possibly mediation in criminals, but I'm smart enough to realize that yes, we got to have a licensed attorney. I do not have a problem with that. I want a licensed criminal attorney to protect me when we go into mediation. But that same attorney has to have a mediator license just as you. So
Well,
she automatically misinterpreted the fact that I was going to find some yahoo, and that's not the case. I take this thing very seriously, and I'm trying to follow the law.
I have no doubt you do. I have no doubt you do. But we're coming from two different angles here, and we're coming from two different assumptions. But the bottom line is, we never had an agreement to do mediation. I'm at that point now where I think this case has been so delayed that I'm not sure mediation is going to help any. I think you, sir, are dug into your position, and I think the district attorney is dug into her position. And I'm not sure that mediation will help, and it only add expense to the deal. So at this point, I think mediation, you've had your chance for it. Both of you had your chance for it. And I think it should be off the table. I think what we need to do now is just set this case for trial and get it tried. And you may have heard me say, oh God, I don't want to try this case again. And you're right. No judge ever wants to try a case a second time again. It's like going through a dream a second time. It's like that movie, Groundhog Day. It's when you try a case a second time and you already tried it. But I also understand that I'm the one most familiar with this case, and for me to just say, okay, I don't want to do it, someone else do it, would be probably a dereliction of my duties, and so I have to try this case a second time. That being said, I'm aware that there's conflicts of personalities between the two parties. That is always normal, but you have witnesses that are fact witnesses, and by that I mean fact witnesses. They were there, they saw the event, they did the arrest, they saw the thing that was taken, they saw this, they saw that, but it's always related to the case. Now, when you get to a point where you start dragging in the attorneys in this case, you got to have more than, well, the attorney was friends with so-and-so who was friends with so-and-so. In my opinion, especially in small communities where everybody knows everybody anyway, I think you got to have something solid to give me other than you think they might have known someone and been influenced by them because of that. That just doesn't, in my book, cut it. So I'm sorry. I don't think there's anything sanctionable in this case. And unless you have some kind of a fact witness, and by fact witness, I mean you have a witness that says, I saw Mr. So-and-so tell so-and-so that Mr. Gilchrist was not going to win this case because of this, or something like that. I mean, unless you have something solid like that, we're not going there. So what I think we have to do now is just set this thing for jury. So let me summarize myself. The motion for sanctions is denied. What we need to do now is set this for jury. Unfortunately, Leela, the coordinator, is not here. I have a pretty busy schedule. I don't know, Ms. Busby, maybe you can tell me, is your county starting jury trials now?
We're starting in June, Judge.
Starting in June. Okay, let me look at my calendar real fast. We had, I think, this set for a jury on June 7th. Am I right about that?
I think that's about right. I know it's sometime in June, but I don't remember the specific date right offhand.
Yes, it's set for trial June 7th.
Okay, I'd like to keep that trial date. Let me just ask you some mechanics on this, Ms. Busby. How do you pick a jury? Do you go to an auditorium?
Yes, we're going to the Fairplex in Uvalde.
And you have enough space there so you can put the whole jury in there and then pick the jury on an auditorium type of area. So there's social distancing, right?
Yes.
Okay. So that's what would happen. Okay. And I suggest that we keep the jury setting and we try this case again one more time. I would assume you pick a jury. Where was that again that you picked the jury? Fairfax?
Fairplex.
Fairplex.
Right.
Okay. And you'd pick the jury there and then you go back to the courthouse and try the case in the courthouse, or do you continue the trial there?
No, we come back to the courthouse to try the case.
And then you socially space the jurors throughout the courtroom. Is that what you do?
Yes.
Okay.
Yes.
All right. And then when they have to go to a jury room, do you put them in another courtroom?
No, we take them upstairs to the jury room, which is a big room.
It's a big room.
Yeah, it's a big room.
Okay. All right. Then let's keep the same jury setting. I'm sorry, Mr. Gilchrist, but I disagree with your arguments on this case. And this case just needs to be tried. Just because I'm not doing mediation does not mean you guys cannot talk to each other if you can be civil with each other. And if you can be civil and try and reach some kind of agreement, that would be great. But otherwise, I'll be planning on going to beautiful, exotic Uvalde, Texas, to try a jury. All right.
For the record, Judge, I've been very civil. I don't know Mr. Gilchrist, nor do I know any of the people that he mentioned other than the former prosecutors. And we are always open to resolving a case by agreement, always. I take nothing personal about this, and I don't mean anything personal. So we're always open to that.
Okay, and my comment is, people need to understand, Your Honor, the DAs, whoever, I'm a very honest person. And nothing really upsets me most unless somebody starts to lie intentionally. It really pushes my button. And we got off on the wrong foot on this. And I just want Miss Busby to know that, hey, I'm willing to work on this, but we got to be fair and honest with each other. No games, no nothing. Just be honest.
I don't play games. So if you...
I'm not saying you do. I'm just saying this is me. Whether it's an employee, whether it's a coworker, or whether it's a business deal, when people start misrepresenting the facts to me intentionally and try and mislead and lie to me, there's a whole nother side of me that comes out.
Okay.
In the respected, I just be fair and honest. That's all I'm asking.
I'm going to ask you guys to bury whatever hatchets are out there into the ground and start anew. And if you can reach an agreement, great. If you can't, great. Now remember, in order to reach agreement, the way I understand it is someone on one side has to give up something and someone on the other side has to give up something.
And that's right.
Middle. All right. If you're not willing to give up anything, there's not going to be an agreement. So, and with that being said, I'm going to ask you all to be excused from this meeting. I guess since my order is in your favor, Ms. Busby, I'm going to ask you to draw up the order. But before you draw up that order, please send it to Mr. Gilchrist for his objections, if any. And I suggest you keep the order simple. And by that, I mean Mr. Gilchrist's motion for sanctions is denied, period. All right. And without any more fancy lawyerese language in it. And if you want me to sign it, then have him approve it and then send it to Leela. And then she'll send it to me via cyberspace and the email stuff. And I'll send it back to her. All right. Okay. Thank you.
Yes, Your Honor. Thank you.
Good luck to you guys.
Thank you.
Okay, Gentry, another fine mess you got me into.
Oh.
Take care, man. All right. It's good seeing you. Say hi to your dad, mom. All right.
All right, I will.
Bye-bye.